Good evening and welcome to Arizona Horizon. I'm Ted Simons. The Ninth Circuit Court of Appeals ruled last week that Secretary of State Adrian Fontes cannot enforce a ban on offensive speech at or around polling places. It's the latest involving questions and concerns over issues addressed by Fontes in the state's election procedure manual. And joining us now is Arizona Secretary of State Adrian Fontes. Good to see you again.
Thanks for having me back.
Yeah, thanks for coming in. Okay, this Ninth Circuit ruling, what do you make of it?
It was great. There was two pieces to this. One piece was kind of kicked out. The Ninth Circuit said the plaintiffs didn't have standing regarding a rule that we had promulgated back in 2023, and that was on certification of elections. And the second piece, we're going to get to go to trial on because the plaintiffs did have standing on that one, and that had to do with threats and intimidation against voters who are potentially standing in line or heading towards polling places, which is one of the things that we wanted to prevent. It's kind of inside baseball stuff because this manual is really a rule book for elections administrators. It's for county officials. It's for folks who are actually at the polling places, like how to run the election. It's not really intended for the general public, although it's available to the public, obviously. Yeah.
But the Ninth Circuit kind of said that what you want to do is too broad and that there could be unintentional consequences here because we're not talking about intent, we're talking about effect. That makes sense to you?
Well, it does make sense to me, but that's one of the reasons why we've kind of already made adjustments. And see, this is one of the things about these lawsuits. And we've seen a lot of these kinds of lawsuits brought by political opponents of mine. These aren't folks advocating for voters, by the way. These are folks who are playing the courts and using them to make political money and political arguments. Here's what's actually happening. Every 2 years, the Secretary of State promulgates the new rules. The Attorney General and the Governor signs off, and these are the new rules. When I do this, I look to the law, state law, federal law, case law. Sometimes these things conflict, so we've got to make sure that all these rules are good to go for county officials. What's happening is political opponents of mine want to game the judicial system, raise their flags and say, oh, we're suing Fontes over this, we're suing Fontes over that, and they can make money off of that with their fundraising. They can go out there and grift off of this. Here's the thing. The 2025 manual, the new one, not this one that's under litigation, it's already being drafted. It's due to the Attorney General and the Governor on October 1st this year.
Right.
And we're going to have a final one in December. So this case effectively is already moot.
Okay, I was going to ask, the things that were brought up here, and again, the idea of trying to police or enforce a ban of offensive speech at polling places could unintentionally ban free speech, unintentionally put a chilling effect on free speech. That was 2023.
Right.
Is that addressed in 2025 in the manual draft so far?
Absolutely. Here's the interesting thing. The plaintiffs that are still pushing this thing, my political opponents who are cheering and saying we won, they already know that we made adjustments in the new draft. They already know that we've made adjustments that really address the concerns that they have. This is one of the few places in governance that's actually nimble and effective and responsive, because every other year we have to draft this manual so that we can make changes based on what the statutes say and things of this nature. So they're really, again, the whole motive behind these lawsuits is to gain political points. It's political theater at the cost of our judiciary, at the cost of taxpayers who have to pay to defend these things that at the end of the day, again, are moot.
Would you not have addressed these issues, though, if there were not court actions?
No, that's not the point. The point is everyone has a public, there's a public input period, and many of the pieces of public input that we've had year in and year out make it into the manual. Changes get made. It is responsive, it is nimble, and it doesn't matter that we get sued in a lawsuit that's ultimately going to be moot. What does matter is the fact that these folks are gaming the judicial system. They're costing taxpayers money to get political points, and we, again, would love to just sit down and have conversations with these folks like we had to draft the draft that's available now, which makes these adjustments.
So there's no sense of any direction or any correction when the three-judge panel of the Ninth Circuit, which is hardly a bastion of conservatism here, three-judge panel unanimously says, no, we're not going for this, even though you say that this is not included perhaps in the next manual.
Here's what the judges said. We're going to go ahead and let this thing go to trial. They didn't say finally and ultimately that this is too much or too little. They said this is where we're going to trial, because the facts haven't been presented on this thing. Remember, this was a question of whether or not the injunction is going to hold. It's not a question of fact. And so all of the evidence hasn't been heard yet. That's the problem here. It's getting sold as a victory. It's a hollow victory, if at all. And what we're doing is saying, look, common sense tells us we want to protect voters from harassment and intimidation. And so that's why the new change says, here's laws against harassment, here's laws against intimidation, here's federal statutes and state statutes. And so the adjustment that we made just says, here's the law. Those of you who want to scream and yell at our voters, who want to try to intimidate them wearing long rifles and camouflage, you may very well be breaking the law, and here's the laws. So we made the adjustments that were necessary. I'm not complaining. If somebody thinks we did something wrong, of course the courts are available. But the problem is the abuse of these systems, and those folks who are grifting off of the judiciary. That's a real problem in my mind.
You mentioned the fact that there would be public input and stuff. GOP National Committee, they're worked up over the fact that they want full public notice and they want comment, and they say that's not happening. Respond.
Yeah,
please.
well, this again, what we had in 2023, not required by law, by the way, because the Elections Procedures Manual doesn't fall in the Procedures Act. Okay, it's a separate thing, and it has a separate timeline than what they want us to use. In 2023, we did 14 days of public comment after 6 months of working with county officials, community groups, and all kinds of other folks to do the draft. They got upset, they sued. And we're like, okay, fine, let's do 30 days. So this year, we did 30 days. Here's the problem. By bringing it under this other set of rulemaking rules, we're never going to actually have a real election procedures manual. We're never going to have one. Like we didn't have one for so many years, and folks complained about it and complained about it and complained about it. Again, political theater in order to grift, and it's an abuse of the judiciary. Our political opponents are doing wrong stuff, and they're pretending like they're doing right. And I don't like the fact that they're abusing our systems for political points.
And I want to ask you this again in a different way here. We can say, granted, they're doing it to make political points. Granted, they're doing it to fundraise. Whatever you say, we'll give you that.
Yeah.
But is it not also helping you, or at least maybe subconsciously helping you, go in a little bit of a different direction?
Look, I love having the conversation with folks who disagree with me because we're going to come up with better ideas. That's what makes America amazing. We have a diversity of thought in this country that has allowed us to innovate in all kinds of different spaces. I just want to sit down and talk with folks instead of spending taxpayer dollars. Do you know I've got a $500,000 outstanding bill from a law firm that we have been defending cases and defending cases and defending cases, and the legislature is just not giving us any money to pay for that. So we literally have a deficit to defend lawsuits that the legislature and their political cronies are bringing against us, which doesn't make any sense. And the taxpayers are footing the bill. I don't care about opposition. Let's have the conversation. Let's have the dialogue. What I do care about is abuse of the judiciary. That's a problem.
The judiciary also, as you kind of referred to earlier, no decision, kind of a punt here on including election results from counties that refuse to certify.
Yeah.
The response there?
Well, we made an adjustment. We saw what was happening, we heard the arguments, and we decided to make an adjustment. I mean, it's really that simple. Here's the thing. Again, Ted, we want to be nimble and responsive when it comes to having these conversations. We want to be mature and effective. But when we have to answer lawsuits and spend tens, if not hundreds of thousands of taxpayer dollars to do it, that's where the real problem is. That's what I've got a problem with.
And I will tell you that from the Republican side, we hear that they basically say you can't register someone to vote if they're not a U.S. citizen. State law says that the application must be rejected. You're telling me, telling us, that if it's a federal form, you put it on hold. If it's a state form, you use something different there. They're not happy about that. And they're also not happy about the state application forms as well, because you're saying, let's give the person the benefit of the doubt, goes through some motor vehicle data, these kinds of things. They're saying no means no. How do you respond to that?
Voters are more important than political opinions. And if we already have the data to show that these folks are U.S. citizens, we're going to go ahead and register them to vote. We're going to follow the law the way the Attorney General does. And oh, by the way, my interpretation of some of the stuff that we're talking about here was a little bit more strict than what the Attorney General's opinion was. We can even disagree. She's a Democrat, I'm a Democrat. The point is this, Ted. People just want us to do our jobs. They're sick and tired of us fighting about every little detail and every little form. And this is what keeps getting shoved down our throats. I just want to do my job and let everybody else live their lives. And this kind of thing becoming a problem is a mountain out of a molehill when someone can pick up the phone and say, hey, Mr. Secretary, can you switch this thing and this thing? And as a matter of fact, we've got a draft of a new voter registration form that literally does that. We take 2 of the boxes on the form and switch them because we got some concerns from some folks. It's not complicated. You just got to call.
All right, the manual is drafted and it's was submitted to the governor and the attorney general, like you said, October 1st?
Our deadline's October 1st. We're going to meet that deadline.
Okay, and how do we know that it's been accepted and we have a new way to run elections that come next year?
There will be some announcement from the attorney general and the governor before December 31st. And once we have that final elections procedures manual for 2025, I assume they're just going to keep on suing us because that's all that they can do.
Well, we'll find out about that. Adrian Fontes, Arizona Secretary of State. Oh my goodness, so much going on here. A lot of it inside baseball, but I think we got a good, accessible kind of way to discuss this.
I appreciate
Thank
you
you so much for coming on.
Thank you very much.